Okay, welcome back, folks. This is House Corrections and Institutions. It's Wednesday, April 30th. We've shifted gears a little bit. It's now 11 o'clock. We have some proposed language that House Judiciary Committee is proposing to put into Senate Bill 109. This is in addition to the other two pieces that we've done. And while I'm saying the other two pieces, there is a sentence reconsideration language that we gave support to yesterday. And in talking with the chair of Judiciary Committee this morning, he has tweaked that language a little bit, added some more people, I believe. So I've asked for that language to be sent to us so that at least we can come back here after the floor this morning, depending on our time frame. This afternoon, but I'm thinking maybe we have time this morning. Don't know. Just to take a quick look at that, because I don't want to blindside the committee that it's been changed a little. So the language before us is two pieces. The first part is what Jen Pullman really requested of us, as well as House Judiciary, dealing with victim notification for when an incarcerated person, a sentenced person, is receiving earned time. And then the other piece of the language is putting in a task force for the victim notification system to really look at the victim notification system. And we have three folks in this committee who have been working on behalf of the committee with all the entities that are working with the victim notification system. It would be with Jen in terms of victim services. It's also with DOC that has the VINE system, as well as our state's attorneys. So I want to make sure that the three folks who have been working with those folks and working together to look at this task force language and weigh in on this for that. So Eric, turning it over to you. Welcome.
Thank you very much. Good afternoon, or good morning, everybody. Nice to see you again. Eric Fitzpatrick with the Office of Legislative Counsel. As the chair said, here to talk with the committee about a couple of sections that are in S109, which is the miscellaneous judiciary bill, which is actually the same bill I was here last week talking with you folks on, but there's sort of the reverse situation. Back then it was developing language with this committee to put in miscellaneous bill regarding county courthouses, which actually, now that I think of it, I should mention, the Judiciary Committee reviewed yesterday afternoon and approved. So that is going into the next draft of the bill as written, as it came out of this committee. But now it's kind of the reverse situation. This is for this committee to look at some language that is in the miscellaneous bill currently, sections 30 and 31. And as the chair mentioned, you have two different but related topics, both involving victims of crime. The first involves the earned time program and some notification procedures with respect to crime victims. And the second involves creating a victim notification task force, which is tasked with looking at notification of victims with respect to criminal procedures general. So that's a bigger picture rather than just specifically with respect to earned time, which the first section deals with, though they both address a crime victim notification. So that's the moment or two of background. And it sounds like the chair, Representative Emmons, you're saying everyone has the language I had sent earlier. Okay, great. So section 30 is the first one on the first page I'm looking at. So this involves the earned time system, which I know this committee is extremely familiar with. Used to be called good time. Long before that, it was called good behavior. It's been gone through. That's right. It's gone through different time over the years. But the concept is the same, which is that if you're someone who qualifies, a qualifying offender, and you're incarcerated, you can earn, I think it is 7 days off your minimum and maximum term for every 30 days that you either don't get reincarcerated for a violation of probation or conditions of release, or you don't basically commit a major disciplinary rule violation. So either one of those two, you have to satisfy both criteria, but if you do, then you can have 7 days, a 7-day reduction off your minimum and max. So that's the general idea.
So by designing it that way, it really puts the onus and the responsibility of whether or not a sentenced person receives earned time, really places it on them. Doesn't, because it's up to them to behave and not have a major disciplinary report. Or it's also up to them to, if they're on furlough, not to violate their conditions of release or create a new crime. So it's really up to the offender to determine whether or not they receive those 7 days permit. And if they violate any of the requirements, they don't receive it. So it's up to the offender to make.
It's
those
dependent on
decisions.
their own conduct completely. Yep.
Offender has control of whether or not they receive it or not.
Yep. So the proposed amendment doesn't actually make any changes to that underlying system. And it instead addresses the notification requirements, some of which already exist in the statute. The statutory list of things that the Department of Corrections has to do relative to the earned time program is what you see in section 30, subsection B. You see subdivision 4, it begins, the department shall. So it lists a few things that are obligations and duties of the department to do. See subdivision A, which is not proposed to be changed, ensure that all victims of record are notified of the earned time program at its outset. So victims have to know about this program, that this earned time structure exists, and they have to be made aware of the option to receive notifications. So they have to be told that there's an option that they receive notifications about the program. And then what substantively has to be in those notifications is what you'll see in the next subdivision B, at least that proposed change. As B is currently written, it provides that not less frequently than every 90 days, the offender has to get notice every time they get a reduction, an earned time reduction. That's the current statutory language. So it's the offender who gets this notice, not less than every 90 days, every time if they get a reduction, an earned time reduction. So the proposed change is to add the victim, a victim who opts to receive notice, to also get that every 90-day notification. Again, there's the opt-in procedure that, as we just looked at in subdivision A, already exists. So there's a structure involved that DOC has that, my understanding is, that makes that opt-in process available. But this provides explicitly that a victim can also choose, because you'll see in subdivision D, there's also a pre-existing opt-in option. This provides that they can also choose to receive this 90-day notice that the offender gets, assuming that they have gotten some earned time during that 90-day period.
So hang on, Kevin. So I have a question, because we did this in this, we put together this statute. And we were very clear that we wanted to make sure that the victims were notified, but they made the decision if they were going to be notified and how. So in A, it says that the department would notify and ensure the victims of record are notified that the earned time program at the outset of the program, when it finally became effective, but also that the department would help the victim be made aware of the option to receive notifications. So our intent there was that the victim would let the department know how often they wanted to be notified. So by adding new language in B, we're really clarifying that not less frequently than 90 days, so at least 90 days, that the victim would be notified if the victim so chooses to be notified.
Yeah, I think it's adding a specific to what this pre-existing opt-in provision that you have for victims.
So we made sure that they could opt in when we originally did the earned time. And that's what's in A. So B really clarifies that every 90 days, the victim still has the option to be notified or not, but it's that 90-day cycle.
Right.
I don't.
English is not my strength. D, when I read the underline, is that equivalent to an offender's earliest release date? Using minimum release dates.
Yeah, that's the earliest. Exactly.
Okay, so how are there multiple earliest release dates?
That I think can change over time. For example, if you've gained earned time, and you get 7 days of earned time in a particular month,
Yeah.
then your minimum release date would drop by 7 days.
Yeah, but that would be a single date. There's a minimum, the earliest release date is such and such.
That changes every month. So at the
I
end of
know,
the year, it
and
would
then we
change.
need to notify them when it changes. Okay, it's earliest.
Yes.
I hear you.
Right.
To me, that's unclear. I would think we would be telling the victims, this is the date, the earliest that they can be released at this point in time. Next month, it may be different, but
I agree with you. I
there's
think that should
one
be,
date that is released,
I
not
think that should be
multiple.
singular
Yeah.
because it's changes in
Sure.
that date, that date changes is what should be.
Right.
Yeah, and you
Once
might well
again,
be
I'm in
right.
agreement
So-
with you, Kevin.
That's a good point. The only thing I would suggest is maybe whether it's talking to the
Yeah, you gotta.
executive director, just see if there's any,
Because there's
see if there's some reason.
calculation, there's calculation there that's very complicated. So Haley, can you kind of circle back and try to find clarification for this today?
On the minimum states?
Yeah,
Yeah,
how that plays out and how it's determined and how often it changes.
yeah, I mean, I think the committee kind of summed it up already in the sense that if an individual is getting earned time, then their minimum release date will change.
Right.
That's also dependent person to person, because someone might, for example, not get earned time every month. So it is very personal, but if someone were to get earned time every month, then their minimum release date would reduce by 7 days each month.
Kevin's question is, why is date plural on this bill?
Changes.
If I'm the victim, I would like to know the earliest be released. That's a single date, is it not?
No,
It changes, but there's only one date.
no,
Yeah.
it's constantly changing.
I know. but-
So you constantly have different dates. Because this is where we really need DOC to weigh in, because that is not calculated necessarily as we think it. It's very complicated, because you use a different calendar to calculate the days. It's really complicated.
Julian calendar.
Yeah, it's very different than what we think. It's very complicated.
Well, no, I see, well, I see what you're saying, Kevin, and I think that at any one moment in time, you're gonna just have one date.
But it
But
changes.
it's encompassing that they should know all the different dates, that way they're seeing the sequence that's following, I get that. So I just don't know if it needs to say date or date.
Right, and that's where we really need DOC to weigh in on how the calculations are done.
Okay, so you're seeking information on how the calculation is done.
Well, and how that plays into their release date, because the question is, should there be, are there a number of release dates? Or is there one date?
That may change.
It's one date that.
It's
Right.
one date, what?
That changes, it probably wouldn't be appropriate to provide speculative dates based on whether an individual earned time for the coming months. So it's just really one date that does change.
Which means that the dates should be changed to date.
In my opinion.
Yeah.
My only language corrections and
Crush it.
That's why we have corrections here and we have our legal.
Next time you bring one up, I'm gonna.
I think that's the question. Would there be any unintended consequences
You made a
if
comment.
dates was made singular?
April.
Right.
Not to my knowledge.
Right.
But I
Can you check
Yeah, sure.
before we go ahead and make a recommendation?
Kevin.
And then get back to us today.
Yeah.
Today, because
prediction.
I know House Judiciary wants to vote this out the next day or so.
Unfortunately, I've got a question about existing language. I don't know if that's allowed. In four
That's
A,
what we're looking at anyway with the word.
so four A, second line, the outset of what? Is that when
The outset of the program, because earn time, when it was put in, had to go through rulemaking. And it couldn't be put in place until the rules were formally adopted. So we wanted to make sure that the victim community knew that as of a particular time, when those department rules were adopted, then earn time could be implemented.
so it's not the outset of a particular inmate earning
It's the
time?
outset of the earn time.
Because they should know ahead of time, right? For any,
Hmm?
because for truth in sentencing, they should know this well before that, right?
They do now, but when this was first put in place, because we used to have earned time and then it was done away with.
Yeah.
And then we reinstated it. So at the outset of that reinstatement, we wanted the victims to be notified that, yes, there's folks who are sentenced, but now they're going to qualify going forward. It's not retroactive, but going forward, they would be able to earn time.
Okay, so this one is
Wanted
almost vestigial, right?
Yeah, it's already happened.
Yeah, okay. Sure.
Just for history, how long was it not in place?
Oh, let me see. We did a lot of work on good time, meritorious good time. We had all these different categories of good time. Good time was very subjective.
Yeah.
It wasn't objective. It was very subjective in terms of who made the decision, whether or not an offender deserved or received earned time. And I think it probably went away early 2000s.
Sounds about right. I think he was away for a few years, right?
Yeah, and then it started
So a
percolating.
relatively short time.
It started,
Did a lot of litigation.
yeah, it's a mess. It's a
Yeah,
mess.
just curious.
And then Council of State Governments recommended reinstituting it as a way to, for offenders to have some responsibility
Mhm.
while they're incarcerated, because it's up to the offender to determine if they behave and
Mhm.
receive it. It's not an automatic. And we wanted to make sure it wasn't subjective, because in the past it was, and there was a lot of grievances that was filed, there was a lot of litigation. And we didn't want that. We wanted it pretty clear. We didn't want people manipulating it and make it very simple, but the Council of State Governments really recommended we reinstitute it as a way of moving folks through the system, but also managing those folks while they're incarcerated. And we took away the subjectivity because we're very clear, no DRs, and you had to abide by your conditions. And if you violated either one of those, you lost it.
Thank you.
So we took out the subjective part. And we tried to make it as easy as we could for DOC for its calculations.
Appreciate it.
So now, anyone after this became effective, and anyone who's being sentenced, they know, all parties would know that yes, earned time is part of the picture here. So even though there's a minimum maximum dates, that can all change. So at the time of a plea deal or a sentence, it's very clear that yes, here's your sentence, but those dates are going to change. For that.
Well, that's essentially the first section. There's also another change. You see a language change in subdivision D, because the point that the chair made that in subdivision A, you have this existing opt-in process that victims have to receive notifications. Under the existing law, that opt-in process really relates to D, which is that you see the last couple of lines say that the department has to ensure that victims who want information regarding changes, and the way it's written out in scheduled release dates, have access to such information. So that's what the opt-in is now. My understanding is that scheduled release dates is hard to calculate, and that an offender's minimum release dates is a date that's more able to be determined and provided to the victim, and that's the intent of that change.
Any other questions? Okay.
So that brings us to section 31, which is the creation of a task force around victim notification generally, and in other words, not specifically about earned time, but about general notification to victims. And there's throughout the criminal law and criminal procedures law, there are various places where victims are entitled to notification of all kinds of different stages in the criminal process, all kinds of different types of proceedings related to criminal process, like the sex offender registry, for example. When an offender is released from custody, the law enforcement agency has to provide notice to victims about assistance, compensation, protection that's available. State's attorneys have to provide information to victims sometimes about appeals and other matters. So these are scattered throughout the statutes, and there's a number of different instances when victims are entitled to receive notification. So what this proposal is to create a task force to review doesn't change any of these substantive instances in which a victim would be entitled to receive notification. It's more about the process. And you'll see that line 2 in the creation language, to improve the responsiveness of Vermont's victim notification system. So the idea is to improve the system overall and not with respect to any particular type of instance in which notification is given. So that's the idea. There's a 6-member task force that's created with the Commissioner of Corrections. And it's always, or designate, the party can always designate another person to serve on the task force in their place. Executive Director of the Center for Crime Victim Services, Executive Director of the Department of State's Attorneys and Sheriffs, member appointed by the Vermont Network Against Domestic and Sexual Violence, Victim Services Director of the State Police, and 2 persons who are either victims or survivors of crimes appointed by the Center for Crime Victim Services. So that's your task force. Subsection C describes what it is they're charged with doing. So generally speaking, study the current state of Vermont's victim notification system, including, there's some specific pieces laid out there, improving victims' accessibility to information, ensuring that the entire notification process is trauma-informed, including all notifications, communications, and informational materials. Expand the use of the automated notification systems, right? So that it can improve the automatic availability option in order to increase options and maximize communication choices for victims and survivors. And lastly, make recommendations for necessary training and resources. Task force is assisted by the Department of Corrections and is required to report back. It's over on the next page now, by November 15th, 2025. So November of this year, reporting to this committee, as well as Joint Justice Oversight and the Senate Committee on Institutions and the Judiciary Committees as well. And then there's some sort of boilerplate language about meetings. And the task force ceases to exist February of next year.
So I'm looking to the 3 of you folks who have been working with the individual parties in terms of the powers and duties section. Does this reflect pretty much the discussions you folks have been having or the information that you've had? Somewhat. Depending on you folks, you've had those conversations with the parties,
With 3 get married.
Mary, Kevin, and Sean.
Yeah, I think this is gonna do what it needs, what we've been kind of all working towards. This is gonna help make that happen.
Because you've been looking at coordination of all the factors, right?
It's happening anyway.
What is happening anyway?
People getting together, not this, I don't think this like,
This task force is theoretically speaking,
yes,
whether it's all of these people or not, I don't know that.
right.
Just that story.
This isn't statutory,
Right, that's what I'm saying. They're doing it formally from the,
Yeah.
okay.
Correct.
but,
That's what we were
but that's DOC, state's attorneys, and the victim services.
Correct.
But this expands it
Yes.
to the network,
Well, state police, yeah,
to the network,
yeah,
to state police, and
Some
also
victims.
to a few victims.
yeah,
Hopefully on May 9th, I think is the current date.
correct.
I'm expecting to hear, I forget Tim's last name, but
Looters.
Lewis,
he's going to tell us how management's going to make sure that the victim's information is captured and put into the Vine system so that it can be used moving forward.
correct.
Because that's the issue. The information isn't
Correct.
getting there. And that's why law enforcement is on this task force, because some of that information is coming directly from law enforcement. And then it goes to state's attorneys, and then state's attorneys is to give that information to DOC, and that's where there's breakdowns. Connor?
Yeah, no, I like these folks are the right people for the job to figure out what we should do. I'm wondering if we're missing sort of the technical expertise on how we do it, right? This is all about technology in addition to what we're doing. And I don't know if it needs to be a voting member, but is there just someone in the room who can stop before the group gets too far ahead of themselves and says, well, that's impossible, or that would cost millions, you know? It just seems like technology is a big piece of this that may be missing a bit.
And that's the Vine system.
Yeah, like,
And who operates the Vine? You contract out for that, right?
Yeah.
And who oversees that contract?
from VOC, our victim services unit, so I think Meredith and Ashley in conjunction with each other. But they're the main liaisons with Vine.
So it's the commissioner or it's designate. So would the commissioner possibly designate one of those folks that oversees Vine?
It would probably be most appropriate, yes.
And maybe we need to try to make some indication that it needs to be within corrections, someone that's working directly with Vine. I don't know, or in consultation with, for that. James, and then we'll go to you, Jen.
This is just because I want to understand the difference. So victims or survivors of crimes. Maybe Jennifer is the best person, maybe you, Alice. What is the difference? I mean, obviously, you're still around, you survived the crime, but everybody's a victim of a crime. It's not because I think it's wrong, I just want to know what it means. You know what I mean?
So Eric or Jen? Do you,
For a gentleman.
okay, Jen, could you just
just
identify
curious.
yourself for the record?
Morning, Jennifer Coleman, for the record, is not. It's really using the terminology that somebody chooses to identify themselves as. Some folks are have just gone to a place in their journey where they identify as survivors.
Gotcha.
May I just, Madam Chair, in terms of one of your questions about a Vine representative, it actually turns out that one of the survivors who's been working most closely with us on the Vine piece, she was interviewed in the big article. She actually now is the representative for Vine in the New England area. So that would be somebody who would be an asset. So that would be somebody who I think would also be a natural point of connection. Vine has identified her as somebody who can bring a Vermont touch and allow perhaps Vermont to be a leader for other states in this area.
So are you suggesting we add that person to the membership of the task force? Or that the task force consult with that person?
My consideration, given that on an asset, speaking out and Kelsey Rice have been involved in this from the get-go and testified before joint legislative to victim survivors. Anna Nassett is the one who currently has a contract, just a brand new one with Vine to do this work in the New England area. But I don't see that there's a need to necessarily appoint somebody specific because I think she would be able to carry both those hats.
So in other words, just I think what I'm hearing, Jen, is that you're saying under subdivision 6, when you're appointing two people who are either victims or survivors of crime, one of them could be that person.
One of them actually would have
Gotcha.
those hats.
But it's the Center for Crime Victim Services that would do that. So your entity would do that.
Yes, and I would be appointing the same two survivors who've been very active and present on this issue for over a year and a half.
But one would be connected with Vine.
Yes, and Anna Bassett has been on the board as an advisor.
Thank you.
So one more way of saying it,
Right.
the information technology representative for Vine happens to be,
Victim.
Also a
Previous
survivor, and
okay,
again, I think that obviously DOC would make appropriate appointments for their designation as well. So I do think there would be that natural overlap, and certainly I don't see anything as preventing the group from consulting with entities. We don't want to be bringing forward recommendations that would not fly. So I see the group as obviously having Vine specifically at the table if for some reason DOC or SNASA were not feeling like they needed to go to the vendor more specifically.
I think I understood.
That's great.
Did you just, I mean, kind of perfect.
I'm wondering if we should just clarify number 6, that two persons,
Right,
victims or survivors of crime, one of which is affiliated with Vine or oversees Vine, some generic
I think you're
language
right.
like that.
There's no guarantees that that'll always be available.
right.
It's just
But
serendipity.
this is a task force that's only gonna last.
Yeah,
Hang on, folks. This is a
Fair point.
task force, it's not in statute,
Yeah.
it's session law, and it's only gonna last until February 15th of next year.
I would definitely make it so that
that person is on this. So one of the two in six, number six, would need an affiliation or connectivity or something to the Vine system.
Want to require it or list it as a preference? 'Cause that person would still have to agree to be.
The
Right,
way it's written, two persons are either victims or survivors
preferably with,
of crime.
can't mandate that this person, this one person that we've identified right now as a really good fit has to do this.
No, but you can rephrase it so that you've mandated that the person who was appointed by the executive director had that experience.
That one of those two people. Right?
Right. You can say, and it's not unusual to do this with study committees, one of whom shall have experience in whatever it may be.
That's a key point, that connection with the phones.
Yeah, I'll probably be in the minority in this, but it is a short-term appointment. And I think that Jennifer is the appointing authority has told us that that would already be the case. So I don't know that we have to clarify. I'm fine doing it, but I'm just saying, like, I have faith in her that she, you know, as she just told us, she's going to make sure that's the appointment.
I have faith in Jen, but I
got
think we need to have it formally put in
Mm-hmm.
this documents so that it's done.
Because the real, sorry.
I
Go
told you
ahead.
I'd be the minority.
Because the real question is, technically, can Vine do it? Or do we need to program Vine so it can do what this committee wants to do?
That's the issue.
That's what I thought we were shooting for.
Yes, and I've been around long enough that I know we put language in and then I get a call in the middle of the summer.
Mhm.
What was the intent? It's not actually clear. Right. Because it gets interpreted differently once it leaves this building. I have great faith in the more clarity we can have, the better. Because I don't want to get a phone call in the middle of the summer. Not that it would happen, but it might.
It
You
interrupted.
always resign, Madam Chair, so then clarifying language is always helpful.
It's always helpful.
Just for the record, Jen, I put it on the record that I trusted you. Okay,
I thank you.
okay,
And we do as well.
okay.
Okay, anything else on this language? So the powers and duties kind of reflect for you three that have been working with the respective parties? Reflects the direction you've been going in, the conversations you've had? Yes. And that was the main reason I really wanted to bring it in here, because I knew you folks were working on it.
Then I give a caveat,
Mm-hmm.
because I'm assuming.
I'm assuming.
May 9th meeting that Tim is gonna say, my team is going to do this. They're gonna be in the court, responsible for collecting the data to begin with and getting it into Vine so that others can use that information moving forward.
Yeah, who's gonna be in the court getting
Yeah.
it?
That's someone from the state's attorney.
The state's attorney are gonna be in the courtroom, getting the initial information from whoever they need, getting it into Vine so that it is available moving forward.
In each of the 14 offices.
Yes.
Good luck.
Yeah. Well, that's what we gotta, that's what we're trying to get to.
So to clarify, so that your group is meeting with Tim on tonight?
No, the whole group is meeting.
No, the whole bunch of people that are, most of the
Wait,
people on this
Okay,
list.
but I mean, the committee's not something you guys have.
No, we don't need you.
And Tim Dumont, Ludus Dumont is state's attorneys and sheriffs, and
Mhm.
he's reaching out. My understanding was he's reaching out to all the state's attorneys to try to get them on board. To get the information into the Vine system,
Right.
because that's where the breakdown is. Yes.
Right.
And then we were gonna bring it back to you.
And that's happening next week, the 9th.
They said.
Yeah.
But in the meantime, Tim was working with all the state's attorneys to bring them up to speed and on board to get a unified practice in place.
So it's more of a job description than legislative mandate. It's, you will do this within your job responsibilities.
Originally, I had said
when it was just going to be the smaller group meeting, that the three of us should be at that meeting, which was supposed to be on the 5th, I think it
Yeah,
was.
don't move to the next.
So the 9th, should we be sitting there to, is that something that's needed
I
for any of the parties, or is that?
don't know. Where was it taking place, Jen? Do you know?
Taking place virtually. I did let Director Pelkey know that 3 of your committee members were interested in attending as flies on the wall. He was fine.
Because remember, we were going to pretty much be quiet. We just wanted to
Correct.
see the process.
It's on the wall.
We just want to be up to speed, that's all, you know, and support where we can.
Well, it's easier to be a
Such
fly on
fear
a Zoom.
flies, but fly on the wall.
And it's held virtually on Zoom or Teams, whatever. Okay. Any
What
of,
time did we nail down on that?
I believe it is 11 o'clock. I'll just tell you in one moment.
week from Friday?
We're gonna change the calendar today.
Mhm.
7 o'clock? Great.
Thank you.
So any other questions, suggestions on this for Eric? So Haley, you're gonna check?
I did.
Okay.
Josh, who,
Josh Rutherford?
yes, he's like the dictionary of DOC, I call him. He said that although the date is variable, it's always only one date, so it would be most appropriate to take away the S.
Take away the S. Good check up there.
Thank you.
Someone who says they don't know English.
So the room across the thing there. And we can do it on the computer and just.
Nervous.
Okay, anything for Eric? So you make that change for date?
Well, would you, how do you want to proceed? It's in the,
We can make recommendations to Martin.
right. I mean, do you want me to just mention it to him? Do you want me to put this into a document and send it to you and Phil so that you yourself can, whatever you want to do, it's fine.
I think a conversation with Martin would be fine. Would the committee be okay with that?
Yeah, I believe in you.
And then you've got some language you've worked up in terms of one of the folks being connected with Vine.
Yes, I think it would read, although I'm not just would want to check and make sure I'm referring to the Vine system correctly, but I had down. So it would read 2 persons are either victims or survivors of crimes, comma, at least one of whom has experience with the Vine system, comma, appointed by the Center for Crime Victim Services. I don't know if that's accurate enough or works for the people who would be doing the appointing or know the Vine system.
Does that cover it, Jen, or do you think it should be more?
For me, it covers it because I've only been considering survivors who had experience with Vine. I don't know if it's specific enough for what the committee was looking for in terms of that technical knowledge.
Yeah, because it says who's experienced Vine or been working, has intimate knowledge, has
Technical knowledge?
technical knowledge of Vine.
I'm more interested in someone that understands the software that's driving Vine to know that they can do what this committee wants it to do. Not that has used Vine, but the one that says the program is set up to do what you are asking me to do.
Mhm.
It's basically a programmer but maybe that's not what the committee wants, but that's what
That's where you were getting at,
Yeah,
too,
technical.
Connor.
right.
Technical.
Representative from Vine.
Yeah,
Understanding of capacity and capability of the Vine capability of the Vine system.
there you
The
go.
technical
You
capabilities.
need a nerd in the room.
That's a good technical term.
Well, then that begs the question, should it be one of those 2 folks to represent the victim community, or do we add another person?
Doesn't have to be a voting member, the other person, you know,
Right.
like, yeah, just have them in the room.
Mr. Khan.
And that person's gonna be the veto power. If they say, they can't do it and it's gonna be $50,000
Right, yeah.
programming, then it's more of a
Well,
veto.
that's not a voting member, wouldn't have the veto.
That's what
So-
I'm saying technically.
How about at least one of whom is familiar with the technical operation of the Vine system?
Or the capability of the operation. It's can it do what the committee wants it to do?
But are we looking at the right person to do that? Being a victim of the crime?
Yeah, I don't think so.
I don't think so. I know what Jen said, but I'm wondering if we should just have a separate, another person
From the
separate,
Sure.
specifically knowledgeable of the capability and technology of the Vine system.
Yeah, that's how you phrase it. Yeah.
It's locked there, Joe. I think you have to unlock it.
Familiar with this big house, yeah.
You want to get away?
Okay,
It falls out the window.
That would be on a Tuesday morning.
very,
I would almost say a separate person.
Separate person.
If the victims, survivor of crime, if Jen appoints a person who's familiar with the Vine system, that's fine.
Yeah,
But
no, I agree.
if you have someone who understands the capabilities and technology of the Vine system, Sean?
Yeah, like how easy is that gonna be to get someone from Vine to be with us? I mean, it's a Zoom, so that shouldn't be so hard.
I don't think it would be necessarily challenging per se, because the victim services unit already works very closely with Vine.
From you all,
Yeah, and
so it could be a DOC person then.
one of the things I would know is that DOC is operating the system. We're very familiar with it, and so I do believe that our team is capable of providing some of that insight. Also noting, which the network pointed out, that the statute states that the group will receive the technical assistance from the Department of Corrections. So I think we would be happy to help provide that insight and also connect with Vine if their presence was needed, if there were things that exceeded our capabilities or knowledge.
Do we want to add a person? Do we want to add a person? So if you don't add the person, we're making a lot of assumptions.
I think that person needs to absolutely be there.
Number 7 isn't, should be.
To be a technical assistance to
Yes,
all of us
a
who know
technical
nothing.
assistant could be interpreted quite different and not technical assistant in terms of Vine.
Well, there needs to be technical assistance
Yes.
in terms of Vine,
I agree.
The
specific.
technical term is a systems analyst. It's what in industry, a systems analyst is the one that understands how it works, directs the programmer to make the hardware changes, software changes, interfaces with the users. It's a systems analyst if you want to use outside terms.
So Eric, what are you working with?
I don't have clarity at the moment. Also,
Also,
who's gonna appoint this person? Yeah, it's also another decision you're gonna have to,
Who's gonna appoint?
not immediately apparent.
Is the person under DOC that would know the software capabilities of Vine?
Yeah, I mean, I think to an extent, we do work very closely with Vine when we are upgrading on software. And so I think that someone from Vine would be involved regardless.
But we don't want to think we want to have them there, period.
That would be.
We can't say we think.
Yeah, that doesn't work for me.
Yeah, we can't say those words, we think.
It has to be present.
Does DII have any role in it?
Yeah,
Department of Information Innovation? No, okay.
Wouldn't it be right underneath the
ADS,
commissioner?
isn't it?
Oh,
Agency of Digital
Did they change it?
Services. It's Agency of.
I'm
Digital-
dating myself.
You're dating,
Yeah, you
it's
are.
not- yeah, it's ADS, Agency.
You know, they do
of
everything for
Digital-
Bishka. It's
Right, it's Agency for Digital Services.
But Eric, would it be like the Commissioner of Corrections or designee, you know, right? And then the Commissioner of Corrections designates a Vine representative there or someone like no,
Oh,
I don't think you can mandate that a Vine staff member is coming to this meeting. This system is incredibly similar to a system I use every day in my job at UVM, where we coordinate all kinds of communications based on the decisions we're making. And it's a privately contracted company.
can we have you go?
No. And we have,
That's my.
anytime we want to tweak the the software, one of our staff members, it's almost always the same person, our office manager, reaches out to the Maxian staff and says, hey, can we make this change? And they say yes or no. It's almost always yes. We can make that happen for you. But it's just a staff member from my department.
But
And there
that's-
are certainly people at the university who have a more sort of technology, sort of system software mindset. I wouldn't feel the need to bring them into the room. It's going to be my office manager, Sue, calling Maxian saying, is this something we can do? And they're going to say yes or no. We'll make that happen.
But there hasn't been that kind of communication to fix this problem throughout this whole problem. It seems like it's a small issue, but it hasn't been able to be coordinated and we've.
Oh, yeah, I don't doubt that there's a
Right,
problem.
and that's what's concerning me is that we've got someone that says, yes, we can do that. And again, it's probably as simple as, well, could you do it for us?
No.
I know I'm only joking, but I'm just saying I think a simple fix, but we have to have someone that can
Yeah.
actually do it and knows what they're doing. Okay?
Well, it's not related to this. I need to run for a minute, but I just want to remind the three of my compadres, we have a meeting at noon. But I need to run to do something before that, so I just didn't want to have you guys forget.
And James, are we going 30 or 60 or we don't know? 41, no, minutes.
Oh, hopefully 30. Cool.
So, Eric, guess are you writing? Have you come up with it?
Yeah, I think if assuming the Commissioner of Corrections can do this, I'd say you could say a member appointed by the Commissioner of Corrections who is familiar with the capability and technical operations of the Vine system.
That's where I was headed.
Good.
And put it right as number 2.
I was adding it as a number 7.
Oh, I was just thinking, because you got the Commissioner of Corrections or designee as number 1. It's fine, whatever works.
Depends whether you want an additional member or not.
Want an additional member? So it brings it up to
Sure.
8.
Yeah, well, I mean,
instead
that's
of
fine. I
7.
mean, it's just, that
Is
person's
there
just there
any
for
voting that
technicalities.
they'll be doing to
I don't-
decide?
It's a task force, so I wouldn't worry about it.
Well, I didn't know if there was any voting, if you would want an odd number.
Think that for a task force like that.
Oh, you
No.
use that word, I don't think.
All right. So where are we? Anything else on this particular language for Vine?
That's good.
Jen, do you want to weigh in at all or?
I think that, with all due respect, I think the committee's heard quite a bit from me on this issue, and I'm happy to give you a few extra minutes with your lunch. I'm really grateful again for the time. I'm really happy with the language.
You supportive of the language? And then you're also supportive of the addition and the earn time for the victim notification, because that came from you folks.
I think that will make clear that it's not just provide accident for these proactive notifications, again, recognizing what committee's concerns about making sure that personal relationship is in fact is elevated. So I think that language gets that and appreciated.
So would the committee be comfortable for Eric and myself to present the changes? The change,
Yes.
date,
Yes.
date, and then the addition on the task force to Martin.
Thank you.
And I'll just say the committee's basically unanimous in this.
Yes, that's what I gotta say.
Okay, it's lunchtime.
Thanks, everybody.
So let's go. We'll be back
Thanks, Eric.
after the
Yeah.
floor.
Okay.